We're live.
Good afternoon. It's the 2nd of April. It's about 4 o'clock. This is the voting session of the House Judiciary Committee. There are two issues that we're going to address. There are technical issues that were in two of the bills that we passed out yesterday. And I'm going to share, put on the screen a document and go through each of the two issues one at a time. Dylan, if you would please share the documents that
I'm downloading it right now.
Yeah. Two issues have to do, one with all right, here we go. This is in Senate Bill 178. And Dylan, I'm sure people may have difficulties reading that. If we could grow, there we go. We'll start here and then we'll move it down here in a moment. So this is the language as it currently exists in 178. The committee's intent, as we discussed the bill and as there have been further discussions in the bill, was to allow for redacting specific information from a police officer from an investigatory file that related to medical information, personal contact information, and information relating to the family and of the person in interest or witness information. However, as it's drafted, it says that the custodian shall deny inspection of a record, not only if the record relates to an active investigation, but also to the extent that the record reflects medical information and the rest. It wasn't our intent for all of that information to mean that you would deny inspection of the record altogether. So what we've done, and Dylan, if you could please go down, is break this into the two parts to better reflect the intent of the committee. So in D, it says that a custodian shall deny inspection of a record if the record relates to an active investigation. However, in E, the custodian may redact the portions of a record in A4 to the extent that the record reflects those four categories. That's the idea. That's what the committee's intent was. The drafting made that challenging. The drafting did not reflect the intent of the committee. So we're going to
move the amendment
on the screen, and we'll take questions from people on this first technical amendment. We'll start with Delegate Griffith, then Griffith, and then Arakan.
Thank you, Mr. Chair. So in other words, this allows for the redaction of information in the case that it's medical, personal contact, et cetera, et cetera.
Correct. It allows for the redaction, but just because there's medical information in it, you wouldn't be able to totally deny the inspection of the record.
Okay, thank you.
All right, Delegate Griffith.
Sorry, thank you, Mr. Chair. Why wouldn't we be able to totally redact medical information, personal contact information related? I mean, why would we? What scenarios? I guess. Let me formulate the question. I apologize. What's a scenario where we wouldn't redact this information?
No, well, and I guess I'm going with, I think, your argument. We want the custodian to be able to redact this information.
Yes.
That it was drafted previously, it would completely allow the information to be completely withheld. The entire file would be completely withheld, as opposed to just that specific information that would be redacted. So this allows within the file for that information to be redacted.
So where this is going towards more confidentiality, not less.
No, it is reflecting the intent of the committee, which was to redact that personal information that would have might otherwise be available by looking at a disciplinary record. That was the intention, was to redact that information. And that was what the drafter thought they were doing, but what they were actually doing was doing a lot more than that.
I don't want to bog this down. If I have another question, hopefully my question will get answered by other folks with their hands up.
All right.
I'll wait to, I still have a question at the end. Thank you, Mr. Chair.
All right, Delegate Erican.
Okay, so I do not, I mean, you guys maybe have been doing this a little bit longer, but I just don't see why this is necessary. What we did originally was we said the things that people are looking for, which is the disciplinary stuff, is now no longer considered a personnel file.
Correct. It's no longer considered a personnel record, but,
Right.
and so for the purposes of the PIA, but the custodian, and because it's not a personnel record, then that information becomes available under the PIA.
Right.
What we're saying is that the custodian can still, even if they are going to release that information, can still redact information based on, redact medical information, the personal contact information, the information related to the family, the witness information. That was what we had discussed from the beginning, was making sure that we could redact that information. And in fact, that's consistent with PIA law in a lot of other contexts.
Yeah, but but this amendment changes the part of the section that has to do with personnel records. But the goal of the PIA was to get the disciplinary records. So what we would need to do is redact from the disciplinary records, not the personnel records. Those are different now. We've divided them into two categories. We have personnel records with all that personal crap in it. And now we have this other thing called a record related to an administrative or criminal investigation and these other things. That is not a personnel record. So if we do this amendment and we change to allow redaction in this part of the code here, down in C1, none of those things would apply, which is where we need the redaction to occur.
What are you talking about in C1?
Yeah, if you look at 4311, we're talking about making changes to,
Dylan, please stop moving the page.
we're
Thank
talking
you.
about making changes to under section what? Section,
D.
we're making a new section called D.
No, there's a D, and then there's an E, there would be a new E.
Can you show me the current language really quick, Dylan?
Go up.
Oh, that's what we're looking at. This is the current language.
That is
So
the
then-
current
So
language.
what's the proposed language? So I see all that.
Go down. Dylan, go down now to the proposed language for 178.
I think the site should be 4351 instead of 4311.
Oh, here we go.
I apologize.
Okay.
That's correct. That's a
Okay.
typo. It should be.
Okay, all right. So let's
351.
so let's jump over. Okay, so now I see where we are. Okay.
Sorry.
That's okay. That helped. That's going to be helpful. Let me see if this makes sense now. Except as provided in subsection C, shall deny inspection of a record. Okay. And now we want to add, all right, this is the proposed language. We want to put an E. Well, we already have an E.
The next part would become F, but okay. E would be.
Okay. Okay, so we're just replacing that E with a new E. Okay, gotcha.
Well, we're
Okay.
not replacing that E with a new E. We're putting in section E, and then the E that's already in the bill would become F.
Right.
We're just.
Right. Okay. I'm confused why. So if we go back to 4311, what does that have to do with?
That's existing law largely that relates to when a custodian shall deny inspection of a personnel record of an individual.
Okay. And we copied that language and put it over
Then
here.
it says who they can check, and that's current law. And then in that section, In C, we explicitly say a record relating to an administrative or criminal investigation of misconduct by a police officer, including an internal affairs investigatory record, hearing record, and records relating to a disciplinary decision, is not a personnel record. So basically what we're saying there, it is not a personnel record, and so would be available
Okay, okay. And now we're gonna add this bit in here.
for 351, not 311.
Yeah,
I could,
Yeah,
if I could change that number, I would. I apologize.
okay, that I think that clears up why I was confused, because
All
it
right.
just didn't make sense in the other section, so,
All right.
okay.
I'm going to go to Delegate McComas. And if it would be helpful, Dylan, if you could quickly just change that 1 to a 5, 351, not 311, that might help people.
Okay, what I'm concerned about is that the way it was, okay, on D originally is that shall deny inspection, okay, if the record relates to active investigation, and then it goes down to the extent reflects medical, personal contact information of the person, witness information, and then relating to a family person. I think it should stay not may, but shall, because you're getting into medical information, and then the one where you go, which will be F, E, custodian shall notify the person of interest when the record is inspected, but not disclose the identity of the person of interest. I think anything having to do with medical information for people, I think it would be better, because the folks that are going to be doing the investigation, they have access. U.S. Attorney, Attorney General, State Prosecutor, State's Attorney for the jurisdiction. So I just have a problem with changing that to a may, and I think it should be a shall for that information that we're dealing with. So in other words, I don't know why we want to change that to a may. It was a shall. I think it should stay a shall.
I think we wanted to break it apart because what the language was saying was that if all of that remained in that same section, that it was not the intent of the committee to say that because something was a medical record that meant that was included in the file, if there were a record that were medical information, that they shall deny inspection of the entire record. That
Doesn't
wasn't
say that.
the committee.
No, not the entire record of what they're looking at, but I think that those 4 items that they shouldn't be allowed in there. I mean, what about HIPAA? There's no protection. And the point is you're not letting this person know who it is. And I just think it's too intrusive, way intrusive. I mean, I think it's dangerous just because the custodian's just, shuffling papers and looking at papers. They may not know that there are unintended consequences here. And I just think there's no reason they need to know the medical information, yeah, and all that other stuff. That's going to cause problems. That's going to come. I think it has a great potential to be misused, and I don't see why we're changing it. Just say shall redact, because once the custodian's got to sit there and parse things out, and the guy's not going to know somebody's interested in the record, who it is won't be disclosed. It could be, somebody that's pretty nefarious. I don't think that's a good idea.
Delegate Cox, then Delegate Moon.
Well, thank you, Mr. Chair. I was going to say the exact same thing that Delegate McComas said, but the point I wanted to make about that issue is that I think it's a mistake because the statute already in 4-304, et cetera, for this from absolutely must shall according to the statute, or otherwise.
Delegate Cox, you appear to have a bad, you want to try again?
Okay. Can you hear me?
Yes, but it's very choppy.
Can everybody hear me? So I'm not sure what's going on. So under Public Information Act Title 4, under 304, et cetera, especially 4306. All of these records, medical information, et cetera, are released. So,
Delegate Cox,
and if
your
you
connection
don't change
is
it to shall
really remarkably bad, Delegate Cox.
for
Sure.
fourth segment.
All right, now Delegate Cox is frozen. We're going to go now to Delegate Moon, and we'll see if Delegate Cox can figure out his connection issues. Delegate Moon.
Thank you, Mr. Chair. I just want to reground the conversation so that folks, I feel like we're careening off course here. This is a very, very simple clarification to what we already passed. So I would urge you to go back to the text of Senate Bill 178 that we had before us. The language in there says that it was confusing. It said it's going to deny information requested during an act of information, and then it's going to deny to the extent there's medical information. And there was some confusion about what that meant. What does it mean to deny to the extent? We obviously meant you take only the medical information out of the record, not you deny the whole record. And that's not what we meant by deny to the extent. So we're just clarifying that. So to Delegate Griffith's question about, well, wait a second, if there's medical information in there, can't you always redact that? I think the answer is yes. It's very easy to take a black pen or the delete button or whatever and just delete words off of a page. And so that's what this amendment is trying to do. It's to say, and to Delegate McComas's question, let me be very specific about this, why you want to make this discretionary. Look at the text again. It says you're going to deny a record because there's medical information in there. Whose medical information? Is it the officer's medical information? Well, yeah, there might be a HIPAA issue there. What if it's the medical information of a person the police officer killed, and the information in the file is an autopsy investigation report about whether that person had PCP in their system? You know, you have to leave the PIA officer the discretion to release that information if it happens to be contested in there. So again, this is not about shall deny, may deny. This is about whether we're going to deny an entire file or just black out the part that needs to be private. The policy of the committee that we're asking you to adopt is that if only a part of the information is sensitive, victim info, we're just going to black out that one sentence and release the rest. That's the amendment. Move the previous question.
I need to respond. That's no,
Mr. Chair, I'm back on.
no.
I'm kidding about the move the previous question.
I'm gonna lose my stuff here.
But that's my honest explanation.
All right, just Moon, just 1 second. It literally says the custodian may redact portions. This is no longer about closing the whole file. The new amendment
No.
says,
the original text was about closing the whole file.
that's fine, but that's not what this is. Our problem is not with the original text. Our concern is in the new E, a custodian may redact. No, we think that they shall redact because it doesn't, there's no,
but
if you want a medical file from the morgue, you can PIA that shit from the morgue. But we want these things redacted.
This file is the complete investigatory file about a misconduct complaint. So if there was a shooting and there was an autopsy and you've got blood toxicology reports from the person that was killed, you've got investigations and tapes and witness information in there, and it's now being requested because it's in the press as one of these hot cases. The question is, if there happens to be an autopsy report in there, does that need to come out in every single case, or should it be up to the PIA officer to do it? I get what you're saying. If it's like, oh, the officer has diabetes and that information came out because there was a tox screen and some HIPAA information came out. But again, the medical information could be all sorts. It could be the defendant's blood toxicology. It could be the officers if they were drunk on the job. It's not clear that it's a HIPAA violation, and that's why it's got to be in the PIA officer's discretion. And that's true
And
for all.
that's an easy fix then. We simply put in there a reference to HIPAA, and we say that, you know, as long as it falls in line with current federal guidance under HIPAA.
But just so you understand the ramifications of what putting the shall deny would be in there, then what if it's the person, the witness information, there's like a 50-page report and there's one sentence that mentions Dan Cox saw the crime happen. I mean,
You just redact that. That's it. This is not about keeping the file anymore. It's now only about the redaction. We're not asking you to deny the file. We're asking you to put a little black line through Dan Cox's name now. That's all we're asking for. Because do you think about it for a second? Let's say we have a police officer. He's involved in a situation, okay? And now the witnesses that have been taken in to talk about him, his friends and family, the other people in the gun trace task force, do a PIA, and now they know all the witness information of all the witnesses that testified against him or said anything against him. That should be redacted. That should all be redacted.
No, number one, the problem is, again, the policy in the rest of the bill that we are, and maybe you disagree with this, but the policy in the rest of the bill we're saying is the public has a right to certain bits, or rather the defendant, the public has rights to certain bits of information. And we're only going to redact that information which might be a problem. If we allow wholesale redaction, then basically you're never going to get an autopsy report out of this PIA. I think that's the problem.
I'm not saying let's do the HIPAA thing.
Officers have not been overly generous. I mean, that's there. I would argue the original language had a little bit of room for discretion. It said deny to the extent. But the concern was a PA officer who's not steeped in this is just going to look at that and say deny. And so we're trying to clearly get them not to do that and to actually engage in some analytical thinking as to whether there is actually a public interest harmed in this. If we don't do it this way, it's going to be an automatic denial in all of this, I think.
If witnesses know their names could be exposed through this PIA process, people are not going to come forward. You will not catch the bad guys, not even the bad police officers. They will not come forward.
Delegate Watson.
Thank you, Mr. Chair. So somebody help clarify something for me. So when we're talking about the PII, I thought we were mostly talking about the officer's PII. And I seem to believe that the may would be appropriate because I just believe that if an officer is under investigation, couldn't there come a time where if the officer was on some type of medication, that would be a valid discussion point, or was undergoing some kind of therapy or something that someone wanted to bring up and tie it to some type of infraction? And if you wholesale say shall and remove it, it seems like some information related to an officer that could be specific to a case could never be touched. Now, what am I missing? I get all the conversation about the witnesses and all of that. I'm talking about the officer's records now. Somebody illuminate me, please.
I'm trying to understand the question that you're asking.
McComas was making a point of may versus shall when it came to medical records. It seems to me that there could be an occasion where the officer's medical records are pertinent to an investigation.
Yes, I think that was what Delegate Moon was trying to say earlier. Delegate Moon, you want to expound on what you were saying before? Delegate Moon,
There has to be some objective person of some type of cognizance that can make the determination on what's acceptable to be redacted and what is not. That's all I'm saying. And if there is a case, and I'm thinking about this because I'm watching, the trial that everybody's watching on TV, how they're going back into this gentleman's records and his frame of mind and drugs he may or may not have been on and therapies and all of this stuff. Officers have issues too, right? And so something that an officer is going through may be relevant to an investigation based on some type of charge. And to say that you can never discuss that, it seems to me you would lose some evidence that might be pertinent. So I think the may is more appropriate than a shall.
This is not about that. This is about a PIA. Judges can already get this information. The police can get this information. And this is not restricting it from a court case. This is restricting it from public access. That's it. This is about a PIA. If you were an officer investigating a crime in which a police officer may have been on drugs, that's all right. You get a warrant, you get that information already. We're not trying to hide it from the judicial process, not even close. This is only about public access to private information that's not relevant to a case that does not have a warrant on it. That's what this is about.
No, I get it, Delegate. My mistake. I was getting PIA confused with PII. All right. That was what I was confusing. The PII, somebody's personal information versus somebody from the public asking for whatever they want to ask for. Thank you for that.
Delegate Grammer.
Thank you, Mr. Chair. I think a lot of people have discussed my thoughts to a large degree. I just think we're much closer to being able to fix this than we realize. For example, like we're talking about legislation where it expands the hiring of police based on the amount of times they've used marijuana or how many months or years they've refrained from using marijuana. I think that's an example that's just not germane to a case, but could be, if they had a card, it could be susceptible to a PIA under this law. And I think, when Delegate Ericon says that we could, medical custodian shall redact portions of the record that are medical information covered by yada, 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 wherever references HIPAA and federal law, which are not germane to the case. I think that's doable. Personal contact information that's not germane to the case. I think this is all doable. I see Delegate McComas's point. I think we could use a shall to clarify, but I think the language needs to be tightened up a little bit. I just think we're much closer than the conversation points to.
Delegate Cox.
Thank you, Mr. Chair. Can everybody hear me now?
Yes.
Okay, I'm sorry. I don't know what was going on with my connection. So what I was just trying to share was that if you leave it as a may, with all due respect to my friend Delegate Moon, this will directly conflict with the statute for the 4300. So Title 4 actually commands that you may not release this information. So a may is not an option. And here's the point Delegate Moon made about an autopsy. It's already handled in 4329. Let me read it. Medical and psychological information shall be redacted or shall not be released other than an autopsy report by a medical examiner. And the reason for that is because they do allow the release of autopsy reports to the general public. But again, as Delegate Watson was mentioning, this is not about an investigation. This is about whether the general public gets this information and can paste it all over the internet. And to say that a custodian may allow witness information to be released to third parties, even people in jail filing these MPIAs. You want to know? I mean, a lot of MPIAs get filed by prisoners in prison. In fact, I would say probably a majority of them are. And they're going to be asking for witness information. We had a case in Baltimore just come down this past week, where they said rats will be, all rats must go. They're going after a witness. And the guy wasn't even a snitch, even though that's, obviously that's not what we're here about. But the issue is, this is personal information. Look at this, the family, we're going to let somebody maybe release the family of somebody in the record. Wow.
Delegate Malone.
You're muted, Mike.
You're muted. Delegate Malone, you're still muted.
Still can't hear
Your
you.
Knocked on-
laptop, still muted.
Yeah, I knocked on the wall and told him, but he said that's not what his laptop is saying. Okay, because I could hear him. Shall I relay what he's saying?
No, it's fine. Delegate Nicole Williams, please.
I was just going to call the question, Mr. Chair.
Let's, I know that Delegate Malone is trying to figure out how to get back on here, and I do want to give him the opportunity to speak because he had not yet spoken before. So let's give him a second to log back in again and see if we can get his audio working so that he can speak.
He's coming in.
All right.
Hello.
All right, let's try that again. Delegate Malone.
Okay, on my laptop, it was showing that I was not muted. I had the green light, but obviously you all weren't hearing me. So anyway, as the lawyers know, and many of the rest of us know, shall is a term of art. Shall means must, means you got to do it. And may means it's optional. And I think it was the intent of the drafters of SB 178 that this is a must. You got to redact these things. The custodial doesn't get to whimsically make a decision. Maybe I will, maybe I won't redact the medical information, the witness information. So the language needs to be shall. Maybe something needs to be different after that, but the word needs to be shall, in my opinion, and I'm not going to be comfortable voting for an amendment that changes it from shall to may.
All right, we're going to hold on to this for a second because the floor is about to happen at 4 and imminently. So I want to get to the second issue and then we'll come back to this one. The second issue, this is the language regarding use of force. This is what the Senate asked for and what is in Senate Bill 71. Police officer may not use force against a person unless a police officer under similar circumstances would believe the force is necessary and proportional to prevent an imminent threat of physical injury to a person or effectuate a legitimate law enforcement objective. That was not what was, in my opinion, what was agreed necessarily, and it's not what the House supported previously. There were further conversations drafting, and there was, I believe, and it was an error, I believe, in drafting going forward. So the language that is proposed, that was the intent, and that was what was discussed in this area, was that the language in Senate Bill 71 is effectively going to be the same with regard to the necessary and proportionate standard that we had in the previous legislation. So the technical change in this use of force section would read, as you can see here on your screen, it would say a police officer may not use force against a person unless under the totality of circumstances, the force is necessary and proportional. All right, that is the difference between those two. There's a motion and a second, and I see people who want to talk. We will start with Delegate Cardin.
Thank you, Mr. Chair. Just very briefly, I got a call from attorneys this afternoon or this morning on this. This is the language that they thought was going to make it easier and better. Is that correct?
I believe so.
Okay.
Yeah,
this
although
is
and the only reason that I'm saying I believe so is I have not heard from the state's attorneys regarding this. So this is
Okay, well,
language.
this was very similar to what the discussion I had. So I'm going to support this amendment because I think this clarifies it and makes it easier for them to prosecute. So
It certainly, I think, is closer to what the intent of the committee was and what was described to the committee when we voted on this, yesterday. We'll go now to Delegate Nicole Williams.
I'm sorry, I think my hand was up.
You were there from before? All right, that's
Yes.
fine. Delegate Fisher, were you there from before as well?
I was, Mr. Chair, and I just had my favorite question, which was.
I know you do, but we're going to let a couple people ask some questions first. Delegate McComas first.
Thank you, Mr. Chair. I'll make this quick. I like the Senate version because it says under similar circumstances. Ours, what we want to put in is totality of the circumstances. The problem is you're not going to be able to create the exact same circumstances of the original act that happened. So I think that theirs is better because it says under similar circumstances and not this, it has to be exactly the same. Because totality of circumstances seems like it's going to be much more hard to recreate that whole thing and take all of those factors into I like the Senate version into consideration. So I'm for leaving it as it is, the Senate version.
Delegate Cox.
Well, I wanted to join in with what Delegate McComas was just saying. We're thinking alike today. I mean, this is not a civil case where you look at the totality of the circumstances and look for negligence. I mean, that's an outrageous standard. It's subjective. The objective standard that is bearing upon cases such as criminal cases should be the reasonable officer standard, which is much closer to what the Senate language is. That's the standard that would apply in the context of the scenario that the officer's facing and what all of the professional training points to. I mean, that's what the intent of this legislature has been, is to say that they want to have highly trained officers. Well, if you're going to have that as the intent, then this should be the language, because if you're going to move to a totality standard where, somebody who's on a jury who's never, once been trained at all in any professionalism of law enforcement or any kind of perception of how to go through the procedures in a use of force situation, will end up just simply making guesses under a subjective standard. So that's why I think the Senate probably focused on fixing that.
Delegate Griffith.
Thank you, Mr. Chair. What I'm trying to understand is totality of circumstances easier to assess Monday morning quarterbacking. So from a prosecutorial standpoint, but use of force is not just supposed to be about prosecution, it's supposed to be about functional and from the law enforcement side, boots on the ground. So how can I, as a law enforcement officer reacting to a circumstance, right, assess the risk with totality of the circumstance when I may not be able to be privy to the totality of the circumstance in the moment? But
I would say, Delegate Griffith, that this is exactly the language that the prosecution is going to have to use in order to prove that the police officer violated the use of force standard. All the circumstances that are there. So yes, this is what the prosecutor would use.
But what I'm saying, that my concern is as a police officer, because when I think of use of force standard, I think of what my instruction, training, and guidance is on how to manage and work through the use of force in any circumstance. But if I'm always in the back of my mind knowing that, well, if I make a mistake, there might be the totality of the circumstance, some information I may not have had in the moment, may cost me all the punishments within the legislation. That's what I'm trying to understand. I'm just trying to understand from a law enforcement perspective, boots on the ground, responding to a call, the totality of the circumstance. How can I work through or live up to the standard of totality of the circumstance?
Well, I think that you would look at the circumstances that you were in. You've been trained, and you would be able to know that you have to use the force that is necessary and proportional given the situation that you're in.
But even that is difficult to navigate. I mean, and one example is, say I have somebody stand in front of me and they have their arm behind my back and they're threatening me and they're walking towards me. I can't positively identify what's behind their back, so I don't know the level of threat. Do I use a taser? Do I draw my weapon? If I draw my weapon and they have a candy bar behind their back, I've way blown out the the proportional force, right? If I have a gun and I'm holding my gun in my holster, waiting to identify what's behind their back, and they have a gun, I can't even draw by the time they're shooting at me. And so now that's the totality of the circumstance, and just I don't even know how to navigate that under this without. And listen, I'm not saying, and I want to be sensitive here, like the last thing I want to do is cause harm to somebody who doesn't deserve it. But just drawing my weapon is a use of force. Presentation of deadly force is part of the use of force continuum, at least how I was trained. And I don't even want to, based on this, if I pull my weapon without knowing I need to pull my weapon, that's outside the use of force continuum. And if I'm wrong, I know this is, you see, you handle it from the other side. I mean, am I reading this right?
Again, I think that the issue here is this is the prohibition under the law. I think that that a prosecutor would be able to use this language as they'd be able to determine how to use this language a little easier, as opposed to trying to show to a jury that a police officer would, under a certain set of circumstances or under similar circumstances, would believe that force is necessary. When you have to show this or prove this to a jury, I think that would be a significant barrier to being able to demonstrate that the use of force was excessive in a prosecution under these cases. Now, to be fair, do you want every law to be only written so that it's easier for prosecutors to get convictions? We talk about that all the time in this committee, and the goal here is to make the law as clear as we can. And I think that's what is proposed, that the finder of fact would look at the totality of the circumstances, all the evidence that is going to be provided by the prosecutor, and then they would determine that the force is necessary and that the force was used was proportionate and proportional to the danger that officer was facing at that time. But I'm going to go now to Delegate Arakan and Delegate Malone.
So I just want to make sure I understand what you're explaining, because I think you have the most experience in this.
To be clear, I have never done, well, we don't have a use of force statute, so I've never done a use of force case against an officer. I've prosecuted cases in the past, so yes.
Yeah, so well, even if it wasn't for an officer, so this type of language, I think, probably shows up elsewhere. If not in statute, then perhaps there's obviously some terms of art in here that are not, that judges use frequently. So if we say police officer may not use force against a person unless police officer under similar circumstances would believe the force is necessary and proportional, I guess I'm having trouble being able to understand application wise what other terms, if we're comparing under similar circumstances to under totality of circumstances, is there other terms you can give to those of us who haven't prosecuted cases like this that we can use to sort of redefine these? So under similar circumstances, what other way could we say that, so that I can sort of better understand how a judge is going to be looking at this?
You're asking me how I would use the language that I want to change?
Yeah, so I'm just trying to figure out if we can sort of use layman's terms to explain under similar circumstances what that means versus under totality of circumstances and what that means.
I mean, you would seek to, you would have to be able to demonstrate similar circumstances. And you'd have to have officers who would testify to what happened under a similar circumstance, which means you might have to have an officer testify to a similar circumstance as opposed to looking pretty much objectively at the totality of the circumstances that were happening at that time. So as opposed to looking at that specific case, we'd have to measure it against maybe finding another officer at another time and under a similar set of similar circumstances to the case that I'm prosecuting right now, which is an additional burden. And not just an additional burden, I think it actually makes it very challenging.
Okay. I think then I'm leaning towards the proposed language because I don't want the burden to be so high that it's impossible for it to be reached. I think that's where I'm going to go on this. I'm not 100% sure. I'll listen to the rest of the answers though.
Thank you very much. I'm going to ask, I'm going to hear from Delegate Malone, Delegate Grammer, and then I'm going to call the question.
From a policy standpoint, I like the way the language is currently proposed. I believe the purpose and the intent of the current language is for the standard to be to look at it from an officer's perspective, from the officer, that is in that circumstance, not to necessarily be using a totality of the circumstance, which takes into other things that may not be quite exactly what was going on. And there may be something, if you did a point scale, there's 10 factors, but there's one of those factors should be 90% of the case. And I think a totality of the circumstances suggests that you would give equal weight to a lot of different things. So from a policy standpoint, I like the language as it's currently proposed. We're looking at putting a heavy burden on our law enforcement, and I think they should have the benefit of it. The way I read it, it means it should be looked at through their eyes or through the eyes of an officer in a similar circumstance. And from a policy standpoint, that's what I think it should be. And I don't like the proposed language, and therefore would be voting against the amendment to change the language.
Sorry, I was muted. Delegate Grammer, were you going to speak?
Thank you, Mr. Chair. And two points here. I believe the totality of the circumstances is the objective and the constitutional standard, but somebody walk me through the practical application here. If I'm a police officer, I have made a stop, for example, I'm questioning someone on an issue, and I feel I need to use force in this scenario. So if I'm trying to figure out what a similar circumstance is, which is going to offer me more lenience in my situation? For example, if I feel that I'm in danger and I have to use force on an individual for this particular stop, do I not have more leeway if whoever is trying to prove facts against me is considering the totality of the circumstances in that particular situation? For example, in a similar situation, in a similar stop, I would typically not use force here. But in this situation, under the totality of the circumstances, someone was approaching me from the side and I feel uncomfortable and I'm saying, please stop, don't approach me right now. My camera's rolling. I'm saying, look, I need you to stop. I need you to not approach me. And he gets too close and I grab a guy, I pin him. Under that example, would it not be the case that the totality of the circumstances would probably allow for that use of force? Because in a similar situation, you would not have to use force. But because of the totality of the circumstances in this case, you're being approached by somebody, you feel uncomfortable, they're coming at you from the side or the back. And in that case, you pin somebody. Does not the totality of the circumstances give more leniency to a police officer in considering all of the factors in the particular example?
I would say that the idea here and the idea in a lot of our areas of the law is not necessarily to try and craft the language to get a result or get something that would be more or less lenient. The idea here is that you want to be able, in every single case where there is a potential use of force, all of them are different. All of them are unique. And that means, and what the proposed language seeks to do is it seeks to say, we're looking at the entirety of the circumstances and looking to see if under those circumstances, the force is necessary and proportional to prevent an imminent threat of physical injury to a person or to effectuate the law enforcement objective. That's what we're trying to do.
Right.
So determining whether it's better in certain circumstances or not implies that all of them just kind of fall on a continuum. And I think that's sort of a false choice. I don't think.
And I get that. Maybe I worded it improperly, but
I get your larger point, but I think that's what this does.
Okay, thank you.
All right, we're going to on Senate. There was a motion and a second to accept the proposed language for Senate Bill 71. We will, all those people in favor of the proposed language for Senate Bill 71, please raise your hands. Please raise your hands if you are in favor of the proposed language for Senate Bill 71. Delegates Williams, Juanica Fisher, and Leslie Lopez in the same picture. Moon, Bartlett, Watson, Davis, Cardin, Conaway, Shetty, Atterbury, Jones, Cham, Crutchfield, Arakan, and Grammer. I see 16. All those opposed? Cox, Malone, Griffith, and McComas. And just making sure that Delegate Lopez is actually speaking with her hands and not actually wishing to vote no. Are you voting no, or you're just speaking with your hands? Okay. In any case, the amended language passes. We're going to go back to the PIA language briefly. And I'm going to go to address an issue from Delegate Cox. Delegate Cox pointed to the language in 4306, and he's right. A custodian shall deny inspection of a hospital record that relates to medical administration staff, medical care, or other medical information. The issue here is it relates back to the issue here kind of goes to any medical information, any information that has to do with the person's health, and the example where, and kind of what we're trying to get at with this, and the reason that it should be a may, is the information related to the investigatory file. One of the probably best examples of this is for Freddie Gray, where that information would not be made available about his injuries that happened after he was put in the police wagon when he was taken in during that incident. That information that falls on the line between whether that information should be available and whether it shouldn't be available, and that's where we have the custodian needing to make that call. With that, we talked about that for about 35-40 minutes. Dylan, or no, that's fine. What I'm going to ask is I'm going to ask us to take the question on whether to adopt the proposed language. The proposed language that was offered. Delegate Arakan has a question, however.
I'm just confused why we can't put some other guardrails in place. I mean, I don't think that's the information we're trying to protect. There are many things listed. There are 4 things listed under there. under the new language that's proposed and under the existing, that's not relevant to any type of case. Family information about the officers, like why would we not say something like must redact personal medical information about the officer, witnesses, the information about their families? Why is that should all obvious? I mean, can we at least agree that should be redacted? Because that was that to my understanding of the original intent of the bill was to redact that information. So we are actually changing what I thought that this body's previous intent was. None of us ever thought that we were trying to redact the morgue file. I mean, the autopsy report, I don't think I was ever under the impression that that was supposed to be redacted. But I'm thinking about what information we would find in the personnel files that's clearly privileged and private information, unless it should come out through the course of a court case or something like that. That's different. I mean, it's not saying that this information will never become available to the public. We're just saying through the PIA process, none of this stuff should be pulled through a PIA process.
Again, this isn't necessarily for the personnel file. It says that we're dealing again with records other than a record of a technical infraction relating to an administrative or criminal investigation of misconduct by a police officer, including an internal affairs investigatory record, a hearing record, and records relating to a disciplinary action. So we're dealing with those. We're not dealing with the full personnel file. We're dealing with the record.
The new file, not the old personnel stuff. We have this new version now, but I still don't understand at what point would a PIA make sense about a person's family?
That's a one question that I think we're going to need to address. Delegate Griffith.
Thank you, Mr. Chair. And so considering this is dealing with police records, are there circumstances where a witness may witness a crime and inappropriate conduct by law enforcement? And the reason I ask that, so say there's somebody involved in a crime and the witness witnessed both, and their information is caught up in a PIA request, and say maybe a friend of the person who's in jail requests the information, gets the contact information, and goes and kills that witness.
I'm sorry, I missed part of that. On my end, I missed what you, Delegate Griffith, I'm sorry, could you repeat that? Because
No, I appreciate that. In a situation where a witness witnessed a crime and also witnessed inappropriate conduct by law enforcement. So now someone who's in jail, who's convicted of said crime, has a friend request a PIA, which includes the witness information. And now that person who's in jail or convicted for whatever reason, we know this is a huge issue of witnesses coming forward in Baltimore City. Commissioner Harrison, even the state's attorney, Marilyn Mosley, talks about witnesses coming forward all the time. And now the witness information is caught up in a situation where it's both affecting the misconduct by the law enforcement and witness to a crime. And now the individual has access to information and kills the witness. That will happen under this without question. This will get people killed.
Delegate Cox.
Thank you, Mr. Chair. Actually, Delegate Griffith just said everything that I was going to say, so I don't need to reiterate it. I think that even though I hear you on the Freddie Gray issue, that's not the focus of the statute. And as we know, the information was able to be brought out with the Freddie Gray issue anyway, separately. But this is talking about basic security. So I would be very cautious to just give it over to somebody who's possibly somebody that we don't know, that's just making whimsical decisions.
Delegate Cardin.
Thank you, Mr. Chair. I'm just going to try and expedite. I don't know if this is something that you want to entertain, but can you just make an additional letter? I think it goes EF. I don't have it in front of me, but you could say E would be may redact the medical records And then F would be shall redact the family and witness information. I'm just putting that out there so we can move on and move the question and try and get out of here.
All right. I think there are some questions that have been raised here that we need to address. We will try and come back a little bit later and do this, but the bells are about to ring for session, so I need to let people go. So for now, that concludes this voting session of the House Judiciary Committee. We will post when we will be voting again shortly. Thank you very much.